Docs v. Glocks Appeals Court rules against Florida gun law. The law restricted questioning of patients about guns by Kurt Anderson. The Associated Press. Miami. A federal appeals court ruled on Thursday that Florida doctors can talk to patients about gun safety, declaring a law aimed at restricting such discussions a violation of the First Amendment's right to free speech. The 11th U.S. Circuit Court of Appeals found that the law does not trespass on patients' Second Amendment rights to own guns, and noted a patient who doesn't want to be questioned about that can easily find another doctor. The Second Amendment right to own and possess firearms does not preclude questions about, commentary on, or criticism for the exercise of that right, wrote Circuit Judge Adalberto Jordan in one of two majority opinions covering 90 pages. There is no actual conflict between the First Amendment rights of doctors and medical professionals and the Second Amendment rights of patients. Circuit Judge William Pryor, who was a finalist in President Donald Trump's search for a Supreme Court nominee, said in a separate concurring opinion that the First Amendment must protect all points of view. The promise of free speech is that even when one holds an unpopular point of view, the state cannot stifle it, he wrote. The price Americans pay for this freedom is that the rule remains unchanged regardless of who is in the majority. The law was passed in 2011 and signed by Republican Governor Rick Scott with strong support from the National Rifle Association. It was the only one of its kind in the nation, although similar laws have been considered in other states. Supporters in the Republican-controlled Florida legislature insisted it was necessary because doctors were overstepping their bounds and pushing an anti-gun, anti-Second Amendment agenda. The law was challenged almost immediately by thousands of physicians, medical organizations and other groups such as the American Civil Liberties Union as a violation of free speech in what became known as the Docs v. Glocks case. A legal battle has raged in the court since then, with several conflicting opinions issued. We are thrilled that the court has finally put to bed the nonsensical and dangerous idea that a doctor speaking with a patient about gun safety somehow threatens the right to own a gun, said Howard Simon, executive director of the ACLU of Florida. The 11th Circuit noted that Florida lawmakers appeared to base the law on 6 anecdotes about physicians' discussions of guns in their examination rooms and little other concrete evidence that there is an actual problem. And doctors who violated the law could face professional discipline, a fine or possibly loss of their medical licenses. There was no evidence whatsoever before the Florida legislature that any doctors or medical professionals have taken away patients' firearms or otherwise infringed on patients' Second Amendment rights, Jordan wrote for the court. Second Amendment to the United States Constitution. The Second Amendment, Amendment 2, to the United States Constitution protects the right of the people to keep and bear arms and was adopted on December 15, 1791, as part of the first 10 amendments contained in the Bill of Rights. 1, 2, 3, 4. The Supreme Court of the United States has ruled that the right belongs to individuals. 5, 6, while also ruling that the right is not unlimited and does not prohibit all regulation of either firearms or similar devices. 7, state and local governments are limited to the same extent as the federal government from infringing this right per the incorporation of the Bill of Rights. The Second Amendment was based partially on the right to keep and bear arms in English common law and was influenced by the English Bill of Rights of 1689. Sir William Blackstone described this right as an auxiliary right, supporting the natural rights of self-defense, resistance to oppression, and the civic duty to act in concert in defense of the state. 8. In United States v. Cruikshank, 1876, the Supreme Court of the United States ruled that, the right to bear arms is not granted by the Constitution. Neither is it in any manner dependent upon that instrument for its existence, and limited the applicability of the Second Amendment to the federal government. 9. In United States v. Miller, 1939, the Supreme Court ruled that the federal government and the states could limit any weapon types not having a reasonable relationship to the preservation or efficiency of a well-regulated militia. 10. 11. In the 21st century, the amendment has been subjected to renewed academic inquiry and judicial interest. 11. In District of Columbia v. Heller, 2008, the Supreme Court handed down a landmark decision that held the amendment protects an individual right to possess and carry firearms. 12. 13. In McDonald v. Chicago, 2010, the court clarified its earlier decisions that limited the amendment's impact to a restriction on the federal government, expressly holding that the 14th Amendment applies the Second Amendment to state and local governments to the same extent that the Second Amendment applies to the federal government. 14. In Catano v. Massachusetts, 2016, the Supreme Court reiterated its earlier rulings that the Second Amendment extends, prima facie, to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding, and that its protection is not limited to only those weapons useful in warfare. 15. Despite these decisions, the debate between various organizations regarding gun control and gun rights continues. 16.